Hello everyone. I, Forum Patel from LG School of Law would like to extend my warm welcome to every viewer. Friends, welcome to the third session of the media law. Now, in the previous two sessions, we discussed about the concept and evolution of media along with the legislative aspect with regard to the criminal law when we are talking about the media segment. Now, then we discussed about the defamation, its exceptions, Sullivan case, and of course the most landmark judgment case, that is the Otto Shankar case. Now in this session we shall be discussing about media and the crime of the sedition. So friends, let's get started. Criticism of government is not sedition itself, my friend. We need to know the exact meaning of the sedition. The definition of the same has been provided by section 124A of the IPC, which defines that whosoever by words which is either spoken or written or by sign which is visible representation or otherwise brings or attempts to bring into hatred or contempt or excite or attempts to excite disaffection towards the government established by law in India, that person shall be punished with the imprisonment for life or with fine, or may be added with imprisonment which may extend to 3 years, or with fine, or with both. Explanations of course can be given for the same thing. So that means, my friend, that any person, in a layman's language we can put it in that if a person is speaking or is threatening the safety of the nation, or is rather instigating other person against the country, or rather even against the government, that act of that individual should be considered as a sedition. So the question in our mind would arise, like whether this sedition is a crime under the concept. If it is a crime, how is it treated under the media law, and whether that can be considered as a threat to the freedom of media or not. Reasonable restrictions when it comes to the freedom, would that be applicable in the sedition cases? So friends, let's get started with answering all these queries. As we all know that sedition is a crime against the state, of course. The word sedition in Latin, it means going aside. The state intends to bring in all kind of the separatist tendencies into the word and curb the writing or the campaign which is causing the disaffection. There are many different case laws with regard to the explanations of the conduct, if they can be considered as a sedition or not. According to one of the decisions in Indramani Singh's case, sedition is a comprehensive term and it embraces all those practices, whether by the word, deed or writing, which are concluded to disturb the tranquility of the state and lead ignorant person to endeavor to subvert the government and the laws of the country. What is the objective of having the whole concept of sedition in our country or in our law? The object to induce this sedition is the rebelliousness. It has been described as a disloyalty in action and it leads to the civil war. So to have that intact atmosphere in our country, that protection needs to be given by the constitution. This offense therefore is the offense of defamation of the government, if we can put it in a layman's language. And the same was the opinion of the court in the Niharendra Dutt case in 1942, that sedition can be considered as a defamation of the government. The term sedition cannot be considered as an offense against the public order, my friends, but the gist of the offense is about the incitement, or rather the tendency to create the public disorder. The Supreme Court in Kedarnath case was of the opinion that citizens' criticism and sedition is somewhere relevant. Moreover, a citizen has a right to say, or rather write also, whatever he likes about the government or its measures by the way of the criticism or comment, so long as he does not incite the other people to get into the violence. When he does so and he incites the people to get into the violent activities, he loses the constitutional protection that has been enshrined upon that individual, which is the freedom of speech and expression. Of course, different from the license. But it further observed, the court observed that the restriction imposed by these provisions, they cannot be said to be in the interest of the public good or public order, because it is creating the disorder in the society. It is asking other people to get into the violence activity, which will be hampering and harming the peace of the public at large. that cannot be allowed, my friends. That would be considered as a crime. This was the opinion of the Supreme Court in the Kedarnath case. Then what about the concept of the reasonable restrictions, my friend, when we are talking about the sedition? No state can be expected to concede freedom of those people who profess to put an end to it by, of course, availing that freedom. And in such cases, there is no point in waiting till they overact and done towards the commission of the crime. Thus, it was held in different cases that sedition is a reasonable restriction over the freedom of speech and expression, of course. To understand, it is very important that we discuss the Bal Gangadhar Tilak's case. In Bal Gangadhar Tilak's case, my friend, the proprietor, editor, manager and the printer of the Bangbasi, a Bengali weekly newspaper, they published certain articles for which they were charged under section 124A and 500 of the IPC. In his speech, he suggested that the government established by the law in British India was thoroughly dishonest and unfair, and that every step should be taken either by violence or by the threat of the violence to abolish the same, which comes within the provisions of this section, of course, as we discussed. Anyone is entitled to hold what political view he chooses, which is provided by his expression, of course, but the freedom is not permitted to degenerate into the license to provoke the other people to breach the peace or to stir up the disaffection towards the emperor or rather the government which is established in our country. To bring the government in the contempt. Can you do that? So this cannot be allowed. This was the opinion in the Bal Gangadhar Tilak's case. The next case that we can try was sedition trial of course, Mahatma Gandhi ji. Sedition 124A was invoked in March 1922 and this was a historical case in context of the sedition. How shall we not discuss Mahatma Gandhi's case when we are talking about the sedition? The accused at this time was Mahatma Gandhi, of course, and Shankarlal Banker, who was the co-accused. The trial was held at the Governmental Circuit House at Ahmedabad, heavily guarded for that purpose on March 1992, which ended by the Justice Robert Bromfield, who sentenced Gandhiji to 6 years imprisonment, of course along with the co-accused. Gandhi did not plead innocence for that. His written statement contained the following sentence. He stated that I hold it to be a virtue to be disaffected towards the government, which in its own totality has done more harm to India than any other previous system. And he concluded his argument by seeking the judgment to inflict the severest penalty. Judge Bromfield replied to the earlier judgment in the trial of the Tilak. In this case, he was also booked under the same case earlier with the 2 other courts. So soon after he pronounced the sentence, Gandhi stood up to say that he regarded the proudest privilege and honor to be associated with the well-reversed name of the Tilak. That was the last occasion when British authority, they put Mahatma Gandhi on trial. On the all subsequent occasions, Gandhi was put to the jail even without the trial. So this was all about the cases with regard to the sedition. So whether can you consider sedition as a crime? At the time before the independence, of course, as we saw in 2 other cases, that sedition was considered to be the crime in the case of Mahatma Gandhi and also Bal Gangadhar Tilak. So whether it is harming the media freedom or not, how can we answer that query? Sedition, whether a threat to media's freedom. Now this case is an example for slapping a case of the sedition against the visible representation and its symbolic communication of seditious messages. Sedition is a weapon generally of the state who uses against the person having opposite political thought or those who are propagating against the foreign rulers and campaign the cause of the self-rule like that of the independence struggle. This section, which is section 124A, which defines as an offense, sedition as an offense, exciting the disaffection against the state, it was replaced with the sedition in 1898. The English law meaning of sedition was basically libel of the government, but in ordinary English meaning, it is stirring up the rebellious actions against the government. The first amendment of our constitution in 1951 incorporated the public order in in Article 19 subclause 2 as a ground on which the state could impose reasonable restrictions by the law. Thus, the inclusion of the sedition was held constitutional by the Supreme Court in Kedarnath case. But the constitution makers did not specifically state that the sedition should be a ground to restrict the free speech. Though the additional ground for the public order is held to be valid for the restrictions of the freedom of speech and expressions, sedition cannot be read as the widest expression along with the public order. This is still a debatable topic, my friends, that whether can you consider sedition as a media threat or media's freedom or not. Reason being that if the media is doing its duty, then it is okay. That cannot be covered under the sedition as a crime. But if the media is trying to instigate the public at large to go opposite to the government and rather to create any violent activity, then what? Should we not stop them also? Should we also go behind the media freedom only at that time? That you need to give an opinion with that regard. The conviction of Dr. Biang Sen was also dealing with the same issue, charging a practicing doctor and social worker, that was Dr. Biang Sen, in Chhattisgarh in 2010 of sedition under this section. He was criticized, of course. If the interpretation of this section by the Supreme Court has to be followed as the law, along with the penal provisions of the IPC, he should not have been convicted. When the investigating police officer were the only crucial witnesses, their evidence has to be corroborated as they are not independent witnesses. Sentencing Dr. Sen solely on the basis of the evidences which were unreasonable and unjustified was criticized on a very higher point. The judgment should at least appear to be independent opinion and be supported by the convicting adequate or available evidences. There are severe bad aspects of the evidence, reasonable doubts and unreasonable contradictions which were involved in his conviction. So friend, that as I stated that sedition is a crime, of course that is a reasonable restriction that we are putting under the constitution segment or constitution radar. But whether that is a threat to the media freedom or not, that will depend from case to case. So this was all about the sedition as a crime when we are talking about media segment. Friends, in the next session, we shall be talking about the obscenity and media at large. Till then, stay tuned and keep learning.